everyone. Welcome to sunny Dubai. We are here for the second of our series of talks, and we're joined by Mr. Fernando Ortega and Michael Lawrence from INSITE, and myself, Jonathan. I'm going to start off by recapping on a couple of the issues we talked about last time. Last time, as you know, we had some technical difficulties. We had issues with internet and issues with sound. Hopefully, they've all been resolved now. We've replaced everything, including the sign. So I'm hopeful that things will go smoothly today, hopefully. So first of all, if we could just ask, for some of you who have not been with us last time, just to ask Fernando to introduce himself and his company so that you can get an idea of where he's from.
Thanks, Jonathan. Hello, everyone. Just a quick introduction. My name is Fernando Ortega. I'm a partner at CVML Limited. It's a law firm in the DIFC, and my specialization is primarily disputes, with construction being the main thing for me. And we're here in the market. We represent contractors, subcontractors, consultants, and the employer as well. So in various arbitration disputes here in the UAE, Qatar, Saudi, and in Europe as well.
And Michael, if you just give us an overview of your background here.
Good morning, everybody. I'm Michael Lawrence. I'm a director at INSITE, and my main involvement actually in the company is related to claims and disputes. And I'm a chartered civil engineer, but also an arbitrator, so I tend to get also involved in arbitrations and so on.
And my name is Jonathan, for those who don't know, and my role here is just to facilitate the discussion. These guys are the experts in terms of the legal arbitration, this type of thing, so I'm just going to facilitate the discussion. So we kick off recapping on a couple of the issues we talked about last time, which is, first of all, just give us an overview. How does arbitration work in the UAE? What are the sequence, or how does it come about?
Okay. Well, I mean, most construction contracts in the UAE tend to specify arbitration as a means of resolving any disputes. There's various different fora that you can go to. The FIDIC contract by default will take you to ICC, which is international forum based in Paris. But most people will tend to opt out of that for the local arbitration centres, which tend to be the Dubai International Arbitration Centre, DIAC, or the DIFC LCIA Centre, which is based in the free zone of DIFC, or in Abu Dhabi, it's the Abu Dhabi YADCAC. Each of those centres have their own rules, but they broadly move along the same lines. Usually, most contracts will specify 3 arbitrators, which means that once you start the arbitration process, which is kicked off by the submission of a request for arbitration, then the other party responds, and then the normal process is that you would then have to nominate an arbitrator. The other side would do the same. Then those 2 arbitrators would together select the chair. And then the process it kicks off to, follows a process which can last, I would say on average, it's about 18 months for a fairly large case. It can be a lot longer, and it can be a lot shorter if there are means to shorten the process, which perhaps we'll look at later.
I think we'll touch on that a bit later. But so, I'm sure as everyone knows, there are 2 ways of resolving this. There's a number of ways of resolving this dispute, but legal terms, there's the court or there's arbitration. So what are the pros and cons of one versus the other?
That's a loaded question. There's a lot of pros and a lot of cons for both, but I mean, the first place you would look is the contract, right? You can't just go to the courts if you have an arbitration clause in your contract, and you can't go to the courts if you can't go to arbitration if you didn't agree to the courts. But let's put that aside. But if we're talking about just pros and cons in general, I mean, the courts here can be very cheap. They can be more They can get you a result a lot faster. There might be some mechanisms within the court that allow you to get something pretty quickly within a month. Thinking about the payment order process. It also depends on the type of claim you have, right? If your court mandates the court, if your contract mandates the court, then it's an outstanding debt, for example, you can go to the courts and probably get a payment order out of that and get in a judgment in about a month. But if you're dealing with just a regular construction claim, the court process can probably take, at least the first instance, will probably take about 6-7 months. And there's a process of appeal for another 3-4 months, and then you go to the cassation court. If it goes that far, you're looking at another 3-4 months, and then the case is finally resolved. You'll have a judgment in hand, and you can go and execute. Arbitration, on the other hand, can be a little longer. Michael said 12 to 18 months, depending who the parties are, who the lawyers are. The arbitration can go a lot longer than that. I've been involved in arbitrations that were only $1 million dirhams dispute, and we dragged it out for 26 months, just to give you an idea. And along with extending that comes the costs, right? The arbitration fees for DIAC, ICC, ADCAC, which is out in Abu Dhabi, DIFC-LCIA, can be pretty pricey compared to the courts. On average, you're registering the case somewhere between 5,000 dirhams to 10,000 dirhams, and then you have to pay the arbitrator fees, and that's all evaluated determined based on the size of claim that you have. So if it's a big claim, price goes up. If it's a small claim, price comes down. In the courts, that's a bit different. You're actually capped, depending on the emirate that you're bringing the suit in, you're capped at 40,000 dirhams usually. It just depends on the emirate. So if you have let's say hypothetically $1 billion dirham claim, you're only paying 40,000 dirhams for it to be heard in the first instance, versus arbitration that will probably be somewhere, depending on the arbitration center, you're looking at maybe $1 million plus just to pay for the arbitration fees. But there's also the other thing with the courts and arbitration is that you get in the courts a judge who is not necessarily someone who's experienced in construction issues or has understanding of construction issues. They're really heavily dependent on an expert. In arbitration, you actually get to select your arbitrators and you get to select experts in the construction field, which makes things go a lot faster and more cost effective to some extent. But the other big thing is that in the courts versus arbitration, in the courts, you don't get your lawyer fees. In the arbitration, you do get your lawyer fees. So you are going through this entire giant process and the fees get racked up. But if you come out with a successful outcome, the tribunal sees your way, gives you an arbitral award in your favor, there's a good chance that you'll probably get not the full amount. It's usually between 40% to 70% of your legal fees. So you get that back. The courts, no, you don't get that back. I can ramble on. There's a lot of stuff here I could talk about the courts, but I think those are the main things.
Let's say I don't want to go to arbitration. I want to go to the court, but my contract mandates the dispute clause as arbitration. Is there any way around it?
Initially, no.
Well, I mean, it's a common practice. I mean, as Fernando said, sometimes you're going to get a better outcome through the court rather than arbitration because of the type of dispute that you've got, and sometimes because of the costs, which of course you will recover. Parties want to go to the court rather than arbitration. Now, what happens is if your contract mandates arbitration, you can always take a case to the courts anyway. However, the law says that if the other party points out to the judge on the first appearance that there is an arbitration clause in the contract, then the judge will say, sorry guys, you're right, I haven't got the jurisdiction, you have to go to arbitration within 8 days.
So is your only chance via naivety of the other party?
It could be, or it could be that the other party hasn't realized, or maybe the other party is interested in going to the courts as well, and they won't contest it. So you can try that approach. The other thing which is happening a lot very often and has sort of having mixed results is that the law says that you can only go to arbitration, or you can only bind your company to arbitration if you've got the right powers of attorney. You've got the power of attorney to do so. So many times parties, and I'm sure you come across this many times, where either one party or the other says, hold on a minute, I know I signed arbitration in my contract, but actually, unfortunately, the guy that signed that didn't have the power to bind the company to arbitration. Therefore, Mr. Arbitrator, you don't have jurisdiction, and I want to go to the courts. So that is something which we see a lot. And as I say, it's having mixed results because the UAE is becoming more arbitration friendly, and they're tending to not allow that means of escape, if you like. And also the arbitrators are the ones that make the decision at the end of the day. And of course, if the arbitrator's sitting there saying, do I have the jurisdiction or not to rule on this, you know, he's going to have a tendency to actually rule, yes, I do have the power, because that means he goes ahead with the case and doesn't go to the courts.
It sounds like they're going to need to establish a case precedent, you know, to fix the ruling on that. Otherwise,
Well,
it'll be different.
you can talk about that. I mean,
What I've seen so far, now that I've seen what the courts have been doing, is every time they see arbitration or the other party raise up to say there's an arbitration clause, boom, goes arbitration. They don't want to hear anything more.
Okay, fine. So,
But some of the tactics I've seen, though, by some of the lawyers, especially the local lawyers who practice in the courts, is that sometimes they will try, if you're a subcontractor, you're trying to sue a contractor and there's a back-to-back provision in your contract, sometimes a way around the arbitration agreement, and you might convince a judge, it just depends how it's worded in the contract, to start the litigation with the contractor and also bring in the employer, and then base jurisdiction on that back-to-back clause. I've seen that work before. And I've also seen it not work too. So maybe just say that.
so it sounds like, you know, not everything is black and white. There's ways and means, and sometimes to take your best strategy or best approach, you need to talk to the right people.
I mean, one of the things here, you know, in this jurisdiction, assuming it's the mainland Dubai, it's a civil court, a civil law system. And that means that there is no binding precedent like you get in a common law, so that's US or the UK. So that means you do get contradictory rulings, and you know, the judges they look at precedent and it informs their opinion, but it's not binding. So it does lead to a little less clarity on some of these things.
And there's another thing that not many people talk about, and it's out there. And I'll be one happy to share. I tell my clients this all the time because it's I know it goes against my interests because I'm an arbitration lawyer, so I'll make my money. So a lot of you know, contractors or just anyone actually who has a contract and it says arbitration in it, let's say hypothetically it says DIAC on it, right? Dubai International Arbitration Center. They think, okay, I can't go to the courts. I got an arbitration clause, so we go to arbitration. But they're telling me, no, I need to get to the courts because I wouldn't want to spend all this money to go through the entire process. Something that there's some rulings in the courts where if, as maybe some of the people out there know, that when you start the arbitration, you have to pay the advance on costs, right? And the arbitration center is going to come off right off the bat and ask both parties to pay half of the share, right, of the total amount. And if one of the parties, let's say hypothetically the respondent, doesn't want to pay that share, which is a common practice in arbitration, and then the center comes back and says to the claimant, look, claimant, the other side's not paying their share, you have to pay the rest of that share. There's case law here, or cases, decisions, court says that if that's the case, the respondent doesn't want to pay, then that respondent has automatically waived the right to arbitration. And the case can be withdrawn, and then at that point, that contractor or company can go to the courts, and there will be no more arbitration.
Oh, okay. So let's look at another question, which is, should the arbitration, this one came in last time from Joe Kelly, so we like his questions, he's very active, which is great. Should the arbitration institutions not have an equivalent of a small claims court for minor disputes to be dealt with expeditiously in less than 6 months with a cap on fees?
So the ICC have what they call the expedited rules, and this is a good thing which not many people realise, that unless the parties actually decide that they don't want to follow the expedited rules, then it kicks in by default. What that means is that for any claim under currently $3 million, the process is documents only. It's a single arbitrator. It's a 6-month process, and the fees are set accordingly. So that's a very good process, which I'm currently involved in one now for a small arbitration. I think other centres are looking at this type of process, but as far as I know, I haven't checked actually the new DIFC LCIA rules, whether they've got an expedited process, because there's some new rules come out that the IFC LCIA this year. They don't. No. But it's something that I think centres are looking at, and I think over time we will see this more often.
I think it's a good thing that it's positive. It's in line with what you're saying, that it is becoming more arbitration friendly and more streamlined.
Yeah, the other option, I mean, you can always, even if you've got, I mean, it's difficult once you're in a dispute, because the two parties can't agree on anything. Normally, not even which hotel they're going to meet in. They just cannot agree on anything. But you can always try, if you think that the case doesn't warrant a big expenditure and a big case, to say, look, our agreement says 3 arbitrators, but really we only need one. We only need a single arbitrator and you could make that proposition to the centre, and maybe the other party will pick up on it.
This would reduce your costs.
Yeah, exactly. It would reduce costs on both sides, but yeah.
CR is the other one that's got expedited proceedings. They have their own rules, and I've seen one contract here that had CR arbitration as part of the. So.
Last time we touched on funding. If you have a major dispute, let's say you don't have the cash flow to take it forward, but you have a strong case. How does that party, that contractor, that individual go about finding this funding? Does he search on Google? Does he call you? Where will he find this potential funding? And when he finds these people who will potentially fund, what does he have to do to convince them?
Yeah, that's a loaded question. Also, there's no one place where you can go and shop around. Like I know in the States they have like a place where you can go on a website and like type in you want this type of insurance, and they'll give up all these different quotes on like what the insurance will be and your price and everything, and depending on what your range is. Unfortunately, the funding world doesn't work that way. And it's you have some funders out there that are trying to promote themselves. They go to conferences. They speak definitely to lawyers. I'm sure they've talked to you guys as well. But there's no one place where they can go. And there's at least I know maybe about 76 funders in the world right now.
Wow.
And it's not just funders who are focused on funding litigations and arbitrations. You also got private investors who will do this. You got hedge funds out of New York that are looking in the market to fund claims. And now I've just found out that there's 3 other services here in Dubai. They're not necessarily law firms. They're just they're like litigation support services companies, which provide not only like reprographics, court reporting, but they also will help fund the case as well, which is ridiculous. Well, not, but which is interesting, I should say. So yeah, to answer your question, there's no one place for a party to go. It's usually done through hearing these type of events or listening to these type of talks, reaching out to law firms, reaching out to you guys who have the contacts.
Yeah, I mean, I would add to that any funder is going to want a legal opinion on your claim. So a good place to start is a law firm, because if you go to a law firm, then you can probably work together with the law firm, and the law firm can then say, okay, I'll help you get the funding. I'll provide a legal opinion, and
they probably have the contacts.
Anyway. And they have the contacts, yeah. So I would say the best place to start is a law firm. There are when I first started looking at a case, looking for funding, some time back, they were all big international companies, and they weren't necessarily operating in the UAE. But now all of the big companies are operating here, and as Fernando mentioned, there are local companies here, and there are local funders which have cropped up.
Okay, interesting.
which is
So there are options for sure.
yeah. The one other option I would mention is another reason to talk to a law firm is you may actually be able to work something with a law firm on a contingency basis, no win, no fee. I'm sure you're happy to take cases on that basis. No, but there are lawyers, there are firms that will do that. There are firms that will look at some of these cases, despite the fact that actually under the rules of the law firms here, they are not supposed to work on that basis, but companies do.
Yeah, I mean, the other advice I would give everyone out there, especially if you are going to reach out to a law firm, many of these law firms have their own arrangements with these funders. A lot of them are from the UK, these funders, and they do to some extent get some kind of preferential treatment, or at least get some kind of better rate potentially for you. I will also be conscious that some of the firms probably won't push you to funding. In fact, they'll try to discourage the whole funding process. A lot of it because it has to do a lot of work for the law firm to do, right? Because they have to work for free for some of them just to get you the funding. And we talk about the legal opinion. Legal opinion on a 100 million dirham construction case is a lot of work, and if they're not getting paid for it, the funding option tend not to be too attractive to them because they all have their hourly rates that they have to meet and that sort of thing. So, but there are some lawyers out there who are very experienced with funding, i.e. me being one. Not that I'm promoting myself or anything, but there's other lawyers out there in the market who have experience.
Another thing is that you see, these funders, what they're looking at is reducing their risk. And if you go to them with a single case and you say, you're looking for funding on this, they'll have an opinion one way or the other. But if you go to a law firm, you may find that through the sort of arrangements that Fernando's mentioned, the funder is funding a number of cases with that law firm, and that means they're spreading their risk. They're not putting all of their funds into one particular case or one particular client. Through the law firm, they're spreading their risk. So, they have a better ability to fund things that way.
Yeah, and some of these funders actually don't even use law firms, right? They actually have their own internal capability to really evaluate the claims themselves. And then they will do the legal part, and then they will come to you guys to do the actual claim bit, right, to prepare that.
Sure. So we have another question, which is, I think we touched on it, but I'm not sure. Can a claimant choose to pay the defendant's portion of arbitration fees in order to proceed if the defendant refuses?
Yes, they can. In fact, they'll be asked to by the arbitration center. But the example I gave was more of like if you're trying to get away from arbitration, of course, it's up your option if you want to pay their fees, but you're not required to. You can always withdraw and then go to the courts. It's just an option.
The other thing as well, depending on the rules and which center you're at, it may well be that if the other side doesn't pay their fees, they cannot raise a counterclaim. They're usually precluded from raising a counterclaim if they don't pay their fees.
Makes sense.
So you pay fees on their behalf, but they can't claim against you. That's normally the
it
case.
Strengthens your position.
Yeah.
Another question, in respect of the funding, if an expert witness states in their report, in their expert's declaration statement, that their fee is not based on a success fee, if they are funded where the funder works on a percentage, is this not a contradiction or contravention within the expert's declaration?
No, well, the experts are going to be paid normally. I mean, they can't be. They remain independent. They have to remain independent with their fees. So the expert, the funder is going to pay the funding costs for the arbitration, whatever it might be. So they'll pay for the lawyer fees. They'll pay for a claims consultant if it's required. They'll pay for the experts. They'll pay for the arbitration fees. So the expert would never work on a contingency. Just the funder, though.
And what is an approximate percentage of the award? I think we said something like 30 or 40%. No,
in terms of funding. Funding, it can vary from 25 to 40, but I think it's sort of 30s more the range, isn't it?
Yeah, I think they've jacked up their the rate over the last year, especially
Yeah.
with the pandemic. I mean, I was seeing rates between 20 and 25. Now I'm seeing 25 to 35%.
You see, what they'll do is they'll look at your claim. The funders will look at your claim, and they will decide how much risk there is in it for them. Now, when a funder's looking at the risk in a construction case claim, they look at things like unpaid certified payments and uncertified monies as pretty good. You know, you're going to get that, providing you can show that you've carried out that work. The fact you've not been paid for it, variations and things like that's a pretty good bet. Extension of time, however, is something which is more subjective, because it relies on delay analysis and then how it's claimed. So at the outset, for a funder, for anybody to look at an extension of time claim and say whether the really is a good bet, a good entitlement there is difficult. So a funder will tend to sort of ignore that for the moment and look at the other pot, and then make a decision based on that.
So let's shift a little bit into another touchy subject, which, as far as I can remember, has always been a contentious issue, which is the old back-to-back payments. So we often see this in contracts where, you know, either the party doesn't read the contract and he signs up to it, or he reads it, objects, and then gets forced to sign up to it, and or gets convinced, don't worry, there's no issue, and then 2 years later there's an issue. So how can people safeguard their interest with the back-to-back?
Yeah, absolutely.
You want me to do it first? I mean, I'll speak on the legal side.
Yeah.
Okay. The back-to-back clauses most in other jurisdictions is not usually it's not permitted, right? It's against the law. Here in the UAE it is permitted. And then here in the UAE also courts, they don't make a difference between if it's paid when paid or paid if paid. They see it as one. So that's just gives some context in terms of the legal set. How the courts have interpreted back-to-back provisions here is very tricky. It depends on the circumstances it's being applied, as well as, more importantly, how the clause is actually drafted. And it also depends on the emirate too. The Dubai courts versus the Abu Dhabi courts see the back-to-back provisions differently depending on the circumstances. So I'll give you an example, like termination. If the contract was terminated early for an event that was beyond the real party's reasonable control, the two Emirates court systems see that how the back-to-back provision applies differently. You'll get two different types of rulings there. But in general, back-to-back provisions, if the subcontractor has finished its works and has gotten TOC or some type of handover certificate from the main contractor, and the project is still ongoing, the main contractor has finished the main works, more than likely the subcontractor, main contractor can say that back-to-back provision is still in effect, and I'm not going to pay you until I get paid from the employer. The subcontractor can't do anything.
Yeah, I mean, the things that I would add to that, I mean, what you have to look at, it's, you know, they will very often use the back-to-back provision to avoid payment to a subcontractor. But you have to look at, you know, well, have the actual subcontract works been completed and handed over and been accepted, maybe accepted by the employer or the employer's consultant. And it could be that the contractor is withholding money. Sure, he hasn't been paid, but maybe he has been paid the elements of his payment which relate to the subcontract. So a simple statement of "I haven't been paid, therefore I'm not paying you." You have to look a bit beyond that and see. And I've seen that tack taken when, in fact, you know, when you look into it and you dig into it, you find that actually the payments the main contractors received do relate to the subcontractor's work, and the subcontractor's work has been certified 100% by the consultant, by the engineer. So you know, you have to look a bit.
I think again it stresses the importance of reading your contract, understanding what you signed up to, and taking advice if necessary, if needed. We have seen instances where subcontractors, subconsultants even, have started working on a project without actually realizing the terms and conditions.
Yeah.
And then through the process, they come to the point where they need to sign up. Maybe they started on the basis of an LPO or a letter of intent, for example, when due to the speed they had to start, but then they find that clause is there. So, and then it becomes an issue. So I think one of the things that we really want to stress is that you have to sign up a contract at the very start.
Yeah.
And be clear what you've signed up to. We've seen an instance recently where a contractor signed a contract which was based on FIDIC, and it had the special conditions, particular conditions of contract, which had been amended. So there was a dispute happened later, and we highlighted one of his responsibilities under clause whatever, and he responded saying, "I don't see that clause in my contract," which was the general conditions of contract. So he had signed up or believed that what was it was all that he was signed up for. He didn't consider all of the other clauses.
Particular
Quite,
Wow.
so it's there, it exists, you know. There are people who make mistakes, you know.
Yeah, and sometimes these back-to-back provisions only apply to progress payments, right? Sometimes they don't apply to retention, or they may retention or apply to any other provisions. So that's something you have to really look at your contract.
The other thing with back-to-back payments as well sometimes is that even if the subcontractor hasn't been paid and the main contractor hasn't been paid because of something of the subcontractor, maybe there's an obligation on the main contractor to pursue that money and chase a claim. The subcontractor puts a claim into the main contractor. The main contractor can't just sit there and say, well, that's not my money, I don't care about that. He has an obligation to chase the money as well. So
I think we've seen this scenario also where a main contractor has not been pushing for the closeout and release of retention on the basis that maybe he has a claim ongoing, etc. And then he's just telling his subcontractors, well, I haven't been paid it yet, so I'm not paying you. They're all desperate for it, but he's holding back. Maybe he's financially sound, he doesn't need it.
We did. I mean, we did see a case where, the main contractor actually converted his retention to a retention bond, but he was holding retention on all the subcontractors. So he had a retention bond and wasn't so minded about chasing it because it's just whereas they had cash held against them.
It happens.
I think it's also important to stress that some of the examples that Michael talked about, especially this one now, I know the main contractor will have the obligation to push the claim forward, but the thing here is that the main contractor most of the time won't tell the subcontractor what it's doing. It'll just maybe refer to that clause or just say that it hasn't been paid, right? And even though it might have been paid, it might say still this to the subcontractor, probably just a delay payment, extend it out. And then the subcontractor is put in the position where, well, okay, what do we do, right? And more than likely, they would have to look at the disputes clause in their contract and maybe even start arbitration just to get this information out of the main contractor, or push the main contractor to do something, maybe take it up to the employer and start arbitration proceedings, or do something, right?
So we've around 10 minutes left. So if anyone has some questions, please just start to fire them through because we can see them live. We have a question here, which is, how do these fees affect the experts only? The arbitrator's fees are paid by the claimant in order to continue with the arbitration. Should the experts not be protected as their primary duty to assist the tribunal?
Well, they are. Sure. I mean, as Fernando said, in a funding arrangement, the funder has certain costs of the arbitration. Okay, and these costs he has to pay. Whatever, it's not a contingency. It's not depending. So he has to pay the arbitration center. He has to pay the advance on cost from the arbitration center for the arbitrator's fees. He has to pay the experts, witnesses, and he has to pay the law firm, to advocate the case and all of those other. So those are all costs which the funder pays regardless of the outcome, and if you like, that's his risk.
So just skipping back to the paid when paid, or pay if paid, Does the subcontractor have the right to formally ask for the approved payment certificate from the main contractor? So in order for the main contractor to get paid, he has to have a payment certificate, which is endorsed by the engineer, etc. Does the subcontractor have a right to ask for that?
Yeah.
Well, under his contract, he may not have a right, and he may ask for it, and he may not get it. But what Fernando has mentioned is that if you get into a formal dispute situation, and you get into arbitration, then yes,
at that point,
that will definitely.
Okay, fine.
Yeah, it's helpful to know that the main contractor is going to probably, especially now in this market, they're going to do everything they can not to give as much information to the subcontractor.
Makes sense.
It also applies to claims and taking over certificates and performance certificates. Very often, the subcontractors don't get the transparency. They don't know whether a claim has been paid to the main contractor. They don't know if he's been issued a taking over certificate or the performance certificate. Those things are, but quite often subcontractors, if they have a relationship or a contact directly with the engineer or the consultant, they can quite often get circled.
So if you've been through the arbitration process and you've won your claim, what happens next? How do you secure your money? How long does that take, etc.?
Well, what you have to do once you have an award in your favour, you have to go and execute the award to in the local courts to get your money. So that is a process which has been it's been eased somewhat with the new arbitration law, in that you go to the Court of Appeal first. You don't have to go into the Court of First Instance as you used to execute the award, and then assuming it's here in the UAE. The great thing about arbitration, though, however, is that if your opponent is an international company, you can actually take that award and go to their home country and execute the award in their home country, which you can't do if you get a court award in your favor unless there is some sort of bilateral agreement.
That's pretty interesting, because often people are afraid in the event of a company going bust, or in the event of them losing a major case, that they will just try to skip and leave. But if you can take that with you and track them down as such, it gives it more value.
It depends on the party you're contracted with, right? So if it's a company that's here, then more likely you won't be able to do that. But if it's a branch company, you can.
Okay.
But the thing that
if it's a company that's here who has closed the door and escaped? So is it?
You're in trouble. You're in big trouble.
It's good to know, isn't it? So if you feel that risk is in the horizon, at least you make the effort and the steps in place to mitigate it.
Yeah. I mean, they would have given you signs before that to see, and the lawyers should have been a little bit more savvy, or at least been up to understanding what that party's situation was, either when they started arbitration or even in the course of the arbitration process. But once you get the arbitral award, like Michael said, you would go to, let's say hypothetically, Dubai courts, because the entity is in Dubai, and you would go to the appeals, and then once the judgment is issued from the appeals, which takes about 30 days or so, depending on if there's a challenge or not, you go to the execution court, and the execution court allows you, given UAE law, gives the execution judge a few remedy options, from imposing travel ban, actually fining anyone, including the managing director of that company, I think 1,000 dirhams a day, if I'm not mistaken, if he's refusing still to pay the judgment, or the execution order, I should say. And
does the interest keep going?
Oh yeah, since the day of the award.
Okay. And interest levels in this country tend to be
9%. 9%.
Yeah, the law says up to 12%, but in reality, 9% seems to be fixed, and it's simple interest. It's not compound interest.
But if you have payment certificates, though, right? The lawyers in your case should have been arguing that the interest starts accruing from the day of the payment certificate becomes valid. So the interest that we're talking about now starts from the day of the award on a general claim. But if it's an outstanding debt that's been owed for some time, say like unpaid invoice or something, then that interest has been accrued since then, and that interest will be dictated by the
But
contract.
since the payment certificate, or from the 60 days, or the time frame they had to release the money?
When it comes due.
Okay, fine.
Yeah, so it's either the day when they sign the payment certificate or the 60 days,
Makes
depending
sense.
on what it says in the
Yeah,
contract.
So another question, materials, and so this is basically a subcontractor has delivered materials, installed, let's say, a chiller on site. A main contractor has not paid him for this work on this material. Does he have any right to recover the cost of this via the employer, for example?
Usually no. Usually there's no access for the subcontractor to the employer, but there can be circumstances. For example, if he's a nominated contractor, then there may be more leeway within the contract. The legal options, I'm not sure. I mean,
there might be a way to bring a claim against it. Well, in general, in some jurisdictions here in the Middle East, you are entitled to bring a claim directly to the employer, i.e. Qatar, where you can actually sue the employer. Here in the UAE, that provision doesn't exist. But given that this is a supply agreement, the chillers were intended for a project on behalf of the employer, there might be a way of arguing an unjust enrichment, maybe. You would have to ask a lawyer that operates in the court. So it would be a court. It wouldn't be arbitration because there's no contractual relationship between the supplier and the
We have another question from Joe. Joe's on fire today, really. Maybe he's the only one online. I don't know. How does the New York Convention apply to local awards being enforced internationally if the company has assets in a signatory country?
New York Convention applies to, I think, over 171 countries now, if I'm not mistaken, and the UAE is a signatory to that. So it's law for UAE, right? It's an agreement that was entered into by the UAE. So the award that's issued here locally can be enforced internationally as well under the New York Convention. It just has to meet the certain guidelines in the New York Convention. It's got to be a valid arbitration agreement. Parties have to be notified. Yada yada.
So, are there any quick and cheap ways to settle a dispute and get paid? Apart from
there are
sending the boys around.
there are, but it's if they're not put into your contract, it's difficult. But certainly, I've seen parties before they get to the stage of court or arbitration talk about. I would say, you've got mediation as an option, and I've seen mediation written into contracts, but I've never seen it used effectively in contracts yet. But it certainly is a quick and cheap way.
Is it used effectively in UK, for example?
Yeah, in other jurisdictions, certainly.
I mean, UAE is behind the curve on this, but do you feel it will become more commonplace?
I like to think so. I mean, I think a lot of these things do tend to follow, like you say. I mean, you look at the whole contracting scene here in the UAE and the FIDIC forms, and there are other forms of contract which are more collaborative and updated, and US UK forms which.
Why do you think FIDIC has been the kind of the norm here for all this time? Whereas in UK there are multiple different types of contracting. Okay, there are different types here, but the rule of thumb is FIDIC. That's it.
Some of it has to do with the community that's come in here and build and doing projects, but also the government's acceptance of FIDIC, right? And some, like Abu Dhabi, for example, accepted FIDIC for all their projects. So I think it's just an acceptance of international standards being applied here, along with the international community coming in.
I think also parties here, it's a transient community. People come and go, and if you can keep as much the same as before that then you've got less risk. And I still have for the FIDIC forms of contract now. I think they're up to a 2019 version, I think, or 2019. But people will still use 1999 and 1987. 87 they would try to use 87, and I've even had one case which was the one before that, 1976 or something. So They tailor their particular conditions to the main contract the way that they like. They learn through experience from one job to the next, what works, what doesn't, and it's difficult to get people to change. Digital change from 87 to 99 is a struggle.
Yeah, true. Understand. I mean, before I came to UAE, I had never heard of it. You know, this was in 2006. We used NEC and GC Works. These type of contracts.
Yeah.
So for me, it was a new experience.
You know what I've noticed also being used now more in the market is ADAPT, which has usually been written out of the contract. But I have 3 disputes now with ADAPT provisions in it. We're going through that process. Even for smaller claims, one was 10 million dirhams, and we're using that.
So we're going to wrap it up, but just the last sort of topic or discussion is, can you table any idea or something that we can do better as an industry in terms of the process or the arbitration? How can it be improved?
Well, there's a number of things you can look at, but you see, you have to look at it as a whole package, because if you, for example, outlaw the back-to-back payments, well, that works well for the subcontractor, but then the contractor then gets squeezed between the subcontractor and the employer, and it doesn't help him. It just you're just going to push the problem up the chain. So you have to look at it holistically, look at the whole thing, and I think here legislation can help, and outlawing contracts and outlawing back-to-back provisions. And also the other thing is, in other jurisdictions you have something called adjudication, which is a quick arbitration process. It's only lasts 1 month. One guy is appointed, and he gets 28 days to make a decision. He makes a decision, and the parties then have to abide by that decision, but it's not binding. So they get the chance to go to the courts or go to arbitration if they don't like the decision, but in the meantime they have to pay. And the idea for that is to keep the cash flow going in the construction industry, and that's been something which a number of countries have introduced.
I think it's a very effective mechanism.
It is,
and it's widely used, certainly in UK.
And it's something that's caught on in many countries, and it just keeps the money flowing. While
I think it's more useful for small claims, for issues which need to be settled quickly.
Yeah, adjudication on bigger claims tends to build into like a mini arbitration. It doesn't last 28 days. It then gets extended, and the law firms all moved into adjudication in the UK. But it's funny, when adjudication started, it was well, okay, we can sort this out without going to law firms. But that didn't last very long, because it's just come in.
Slippery lawyers,
we got to get our piece in the market.
Yes. So what about you, Fernando? What do you think we can do a bit better?
I think primarily it goes down to the basics, right? It's the contract itself. Some of these contracts, even today, that I've seen are still poorly drafted. Parties are not properly identified, and then that becomes an issue. It's not an issue when you start, but it's an issue when you get into dispute. And we're talking about enforcement of the award. That is when it really becomes an issue. Because if you're suing the wrong party, the award you get is not going to be valid. So it's helpful just to have clear contractual terms, identify who you're contracting with, and make sure that dispute process is, or at least the disputes clause is properly drafted, clearly drafted, and avoid a lot of problems.
Cool. So I think that wraps us up for today's discussion. If anyone has any questions, feel free to ping them through either via the Zoom, or you can email us directly on info@insite-pm.com, or give us a call or send a message. Anything really. We're open for discussion, open to help, assist, and help anyone who needs help, basically. So we bid you farewell for today, and let's see you next time.
Thanks very much.
Thank you.
Bye-bye.